In February 2026, a late-night interview, pulled before it reached the air, reignited a public debate about censorship and the government's role in media regulation. Stephen Colbert's Late Show had booked an interview with Texas Democrat and senatorial candidate James Tallarico. However, before it could reach air, CBS intervened. The network, through its lawyers, informed Colbert that the interview would not be broadcast and instructed him not to discuss the network's decision or even to name Tallarico on air. CBS's position, elucidated by its legal team, was that allowing a Democratic primary candidate to appear on The Late Show could create regulatory complications under a stricter interpretation of the equal time rule. The cancellation unfolded within a broader climate of intensifying antagonism from the Trump administration toward late-night talk shows, whose opening monologues routinely incorporated satirical critique of the president, his policies, and his appointees. Their jokes and the selection of some political guests led several public officials, including FCC Chairman Brendan Carr, to accuse late-night hosts of taking advantage of the reduced statutory restrictions on talk show content to promote a politically biased agenda. The regulatory structure at the heart of the current controversy first appeared in the Radio Act of 1927. That statute created the Federal Radio Commission and established a federal licensing system for broadcast stations to use the public airwaves. Stations did not own the frequencies they used. Instead, they leased access under licenses granted by the federal government. Because these agreements depended on federal authorization, Congress required that licensees not be allowed to use their individual discretion in deciding which candidates for public office would be granted or denied access to the airwaves. When communications regulations were reorganized in 1934, the Federal Radio Commission was replaced by the Federal Communications Commission. The equal opportunity requirement was carried forward into what became Section 315 of the Communications Act. The principle embedded in that provision was straightforward. Access to public airwaves came with attendant public service obligations. The equal time rule emerged from a specific regulatory logic rooted in the relative scarcity of broadcasting outlets in the early decades of the 20th century. It was designed to prevent overt favoritism by license holders and ensure political parity in candidates' access to the airwaves. Practically, what this meant for stations was that opposing candidates had to be given equal opportunity to broadcast their message whenever a legally qualified candidate was given broadcast time. Specifically, it required stations to offer comparable time at similar rates and under similar conditions. But the effectiveness of the equal time rule from the beginning was limited. The statute attempted to regulate parity in the amount and conditions of access to the airwaves by politicians themselves, but it could not address the overall distribution of on-air attention given to a particular candidate, which was influenced by variables such as incumbency and involvement in newsworthy actions. Throughout the 1950s, audiences for radio programming began to decline as television emerged as the dominant broadcast medium. Television programming introduced new formats, making compliance with the equal opportunity requirement more complicated. Unlike the formal campaign speeches that were staples of early radio programming, television innovated new formats that increasingly included interviews and news segments featuring candidates in conversational settings. If a legally qualified candidate were interviewed on such a program, that appearance forced an assessment of equal opportunity obligations and the potential that a station would be required to provide a comparable time to every opposing candidate. Strict compliance with those obligations would have been untenable for a rapidly evolving medium, increasingly defined by interviews and unscripted exchanges rather than formal campaign addresses. In 1959, Congress amended Section 315 of the Communications Act to address the problem directly. It created 4 exemptions for bona fide newscasts, news interviews, news documentaries, and on-the-spot coverage of news events, so that appearances by legally qualified candidates within those categories would no longer trigger equal opportunity requirements. In essence, Congress adjusted the mechanism of equal opportunity without abandoning the underlying principle that political parity within licensed broadcast spaces should be preserved. The following year tested that principle with the advent of a now common feature of presidential campaigns. In 1960, the nation's first televised presidential debates featured candidates John F. Kennedy and Richard Nixon, and exposed a structural conflict between the equal time rule and this new format. The debates did not clearly fall within any of the 1959 exemptions, and according to the logic of the equal time rule, if one network aired a debate featuring only the two majority party nominees, other legally qualified candidates could plausibly claim a right to comparable airtime. Rather than reinterpret the exemptions to permanently include this new campaign forum or eliminate the regulation altogether, Congress temporarily suspended the requirements of the equal time rule to allow the debates to proceed. By choosing suspension over repeal, lawmakers preserved the principle of equalized candidate access, even as the public format of political communication was shifting. Over the following decades, the FCC interpreted the statute with increasing flexibility. In 1975, the Commission determined that a certain broadcaster-sponsored debate could qualify as on-the-spot coverage of a bona fide news event. And in 1984, the FCC allowed broadcasters to host debates that excluded candidates based on reasonable, neutral, nonpartisan criteria, such as a candidate's viability for office or a fundraising threshold. These adjustments did not eliminate the equal time rule or abandon the assumption that fairness in elections could be addressed by regulating appearances on licensed broadcasting stations. They simply allowed broadcasters to exercise newly expanded editorial judgment about whom to include in debates. The regulatory framework established by the equal time rule was tested once again when political candidates began appearing on a new television programming staple. Talk shows were not traditional newscasts or debates, nor did they include traditional campaign speechmaking. They frequently featured political candidates in conversational settings, which made determining whether they qualified for one of the 1959 exemptions or triggered an equal time requirement a regulatory challenge. In 2006, the Commission granted an exemption for the interview portion of The Tonight Show with Jay Leno, treating it as a bona fide news interview. That decision, which has controlled equal time determinations for 20 years, signaled that late-night interviews could qualify for the exemption, provided they met certain conditions. The January 2026 guidance from the FCC, however, cautioned broadcasters not to treat the 2006 Leno decision as a blanket shield against regulation of partisan material. It further insisted that each appearance must meet the statutory criteria. They had to be part of a regularly scheduled program, under broadcaster control, and conducted in good faith rather than for overtly partisan purposes. Assessing the show's compliance with the last of those requirements has once again put the difficult relationship between talk shows and the doctrine of equal opportunity in sharp relief. The equal time rule was written for a world of 3 dominant networks and scarce broadcast frequencies. It was a regulatory attempt to ensure those resources were not used to promote partisan agendas. However, while traditional broadcast stations remain bound to the statutory framework of the early 20th century, contemporary political speech also circulates through cable channels, podcasts, streaming platforms, and social media platforms that fall well outside those broadcast licensing agreements. The regulatory disparity raises the question of whether a statute designed to control a concentrated broadcast system at the beginning of the 20th century can meaningfully shape electoral fairness in a newly abundant media environment. Considering the history of the equal time rule and the changing conditions it was designed to address, the cancellation of Stephen Colbert's planned interview with James Tallarico, coupled with the government's recent warnings that talk shows may face greater scrutiny under the rule, raises a question of statutory fit. A provision designed to regulate parity in candidate access to limited broadcast frequencies does not map neatly onto late-night interview in a media environment where political speech circulates across an expanding range of platforms. Invoking equal time in this context does little to clarify the content concerns at issue. Instead, it underscores the distance between the regulatory assumptions of 1927 and the institutional responsibilities and constraints facing a contemporary FCC attempting to apply them.